With those announcements in mind, let me introduce our first two speakers. Bill McMahon is a partner with Constangy Brooks and Smith in Winston-Salem, North Carolina. In an era where very few cases go to trial, Mr. McMahon has substantial trial experience, both in federal and state courts, in bench and jury trials. In 2010, Mr. McMahon began serving as an adjunct professor at Wake Forest at the law school where he teaches employee benefits and pension law. He received a BS degree in accounting, summa cum laude from the State University of New York, and a JD degree cum laude from Wake Forest University School of Law. His most notable recent achievement is after having an 11-year-old daughter and an 8-year-old daughter, 3 weeks ago he gave birth to his third daughter, or maybe his wife gave birth to his third daughter. Josh Van Kampen is president of Van Kampen Law in Charlotte, North Carolina, where the principal area of practice is employment law. He's a member of the Employment Law Council of the North Carolina Bar Association, the North Carolina Advocates for Justice, the Southern Trial Lawyers, the National Employment Lawyers. You must like employment law, Josh.
Yeah, I'm a one-trick pony.
He received his BA degree from Purdue University in 1993, his JD degree from the University of Illinois College of Law in 1998. I'm not aware that Josh has any new children in the family, but he did give birth to a substantial trial verdict about 2 weeks ago, and so both of our speakers have something to be proud of. Thank you, guys.
All right, thank you very much, Griff. Appreciate it. The first topic of today that Josh and I are going to co-present for everyone here is really an introduction to the federal employment discrimination and retaliation statutes, and specifically Title VII, the ADEA, the ADA, and the Equal Pay Act. For a lot of you guys here, this is going to be review if you have any employment law experience. The scope of today is designed, though, to kind of be a primer for everybody. So it's a review of the basics, and for those of you guys that may not already be in employment law practice, hopefully you'll take something out of today in terms of kind of what to expect and the different kind of sub-areas of law that make up this really interesting area of law. And specifically today, with what Josh and I are going to cover, what we want to try to convey to everyone is really kind of some of the proof schemes involved in these claims, both from the plaintiff side and also from the defense side as well. So diving right in, it's kind of important to understand where we are. Obviously, in this session, for the hour that Josh and I have with you, we're going to be talking about federal laws. And it's not automatic when you're dealing with employment discrimination issues that you are necessarily going to be dealing with federal law. We're actually going to be having a state law segment immediately following this, and so you'll see kind of how that works. But suffice it to say, in order to have a claim under Title VII or the ADA, first you have to think about coverage, okay? As is the case with the ADEA as well. And there's different thresholds for coverage depending upon which statute you're talking about. For Title VII and the ADA, in order for an employer to be covered, they have to have 15 or more employees employed in each of 20 or more weeks in either the year the charge of discrimination is filed or the year prior to that. Same sort of analysis for the ADEA, or the Age Discrimination and Employment Act, but that numeric threshold is 20 employees rather than 15. Okay. And in counting the numbers of employees, there is some nuance to this. For purposes of the segment today, suffice it to say that you can have a situation where there's related companies whose employees can be aggregated together in some circumstances to try to get to that 15 or 20 number. Okay. The other component to this is technically you do have to be an employer that affects commerce, but as we all know from our practice, that's pretty much anybody. Okay. In terms of the entities that are covered, it's technically not just employers. Labor organizations, employment agencies, there are oftentimes when individual supervisors are named as defendants, although we'll see there's not really coverage for that. And then you have a situation where there's third parties that get named as employers as well, and we're going to dive into each of these. Okay, first, in terms of the private employer discussion and counting the employees. in addition to my point that I just made a moment ago on how you can have a scenario where there's related entities whose employees are aggregated together, there's also kind of an interesting issue in terms of how you actually count the employees to begin with. And again, in most circumstances, you either know you have this numeric threshold satisfied or you don't. But in close cases, counting the specific numbers of employees might actually really matter to determine whether you have Title VII coverage or not. And there was an important Supreme Court case that was decided back in 1997, the Walters case, that basically said that you need to count all the employees on the payroll for a given week, not necessarily whether they are actively working during that week. So it established more of a payroll test, if you will, and that helps kind of, delineate and make sure that everyone's on the same page in terms of the coverage decision and whether or not, there's actually coverage under Title VII to begin with. You're not going to get into day-to-day analyses of whether or not this person was actually actively at work or what they were doing. The question is simply, were they on the payroll for the employer for that given week? Okay. A couple statutory points to keep in mind in terms of who is not covered, even though numeric thresholds might be satisfied. Statute specifically references that the U.S. government as a whole is not covered. The Indian tribes, bona fide private clubs, which is an exception that comes up from time to time, and then certain religious corporations and associations as well, where membership in that association is required to perform work connected with the mission of it. Okay. Important to note, though, that Title VII does cover state and local governments and most federal employers in terms of actual U.S. agencies, including Postal Service. Okay. Unions can also be liable or potentially named as defendants in these sorts of cases as well. Okay. They're obviously liable for their own employment and membership practices, and they can also potentially be liable indirectly in the sense that if a union was, for instance, directing an employer to perhaps cause or attempt that employer to discriminate against an employee, it's at least possible that a union could be named as well. Employment agencies, they are covered if they take action to procure employees for an employer or procure employment opportunities for employees. It's often a situation where you might have an employment agency named along with the proper employer as such, and you get into a dispute as to whether or not, one or both entities are technically employers under the statute. But oftentimes, courts will find that they both are. When it comes to individual supervisors, as I mentioned a moment ago, the general rule here is that they are not liable and really not properly named as an entity that can be sued under Title VII. It's probably a more accurate way of phrasing it. Bottom line there is that even though a supervisor might have a good degree of control over the decision at issue being challenged, courts conclude that they're not really the employer as such, and accordingly they can't be named as a defendant under Title VII. Now, the next session coming up immediately after this, we're going to get into state law territory, and as everyone knows, individuals can always be liable for their own torts that they commit. And so supervisor liability is going to come into play more so when we start talking about claims that arise under state law. And finally, third parties, when we're talking about staffing agencies, PEOs, temp agencies, things like that. That's a dynamic, again, where courts will decide whether or not there's essentially kind of a joint employment relationship between the entities as compared to or in connection with the employee challenging whatever discriminatory act he or she may identify. Okay. And obviously, the primary employer in that situation is going to be that entity that essentially utilizes the day-to-day supervisory responsibility to manage the employee and has the right to hire and fire the employee. Oftentimes in those situations, you run into an issue of, who the actual de facto employer is. And again, it's a scenario where often the, W-2 or formal employer is named along with another entity. Josh is going to pick up from here, talk about types of claims.
Just do that one there. So I gave Bill the boring slides on purpose, but he has some fun slides next. So that's the boring part of the presentation is coverage. So the more fun stuff, it has to do with proving discrimination. So, what are the different routes to prove discrimination? And then I'll be focusing on what's called disparate treatment, the disparate treatment route to proving evidence. And really what disparate treatment is a fancy way of saying different treatment. Is the employer treating somebody in a protected category differently than someone who's outside of a protected category? Now, in order for you to even go to court, your client will have had to have suffered something called an adverse action. So picture a federal judge who's got a busy docket, and you have to come there with something important enough that the judge is like, you're not wasting my time with this, would be a way to explain that. So for example, obviously a termination is an adverse action that wouldn't waste a judge's time, so would a demotion, so would a failure to hire. That's a closer question when you talk about a lateral transfer, for example, where the money didn't change. Is that an adverse action? It depends on how substantial the job duties have changed. But these are all things that you need to have in the first place in order to bring a disparate treatment claim. Now, what a plaintiff has to prove in these cases is that the employee was discriminated against because of a protected category. So what does because of mean? We don't have to show that the only reason why an employee was terminated was a protected category. So just understand that right out of the gates. It doesn't have to be the only reason. There can be other reasons in play that the employer has come forward with. Our obligation is to show that the discriminatory reason was an important enough factor that it tipped the scales to the termination. So because of doesn't mean the only reason. It just has to be a significant enough reason to tip the scale to a termination. Now, the traditional way to analyze discrimination evidence, especially at summary judgment, is running through something called the McDonnell-Douglas test. For the aspiring or current plaintiff's attorneys in the room, you will rely on the McDonnell-Douglas test at summary judgment. You will not rely on McDonnell-Douglas test with a jury because it's too confusing, and you want to make it simple. But for summary judgment purposes, you'll run through this process. And I have not skipped any slides. Okay, so here are the factors. So we talked about one already, protected class, 2, adverse employment action. The third is that the employee is qualified or meeting the minimum qualifications. And then fourth is that there's some other evidence of discrimination that rises to a level that it's important enough to move to the next step. All the plaintiff's lawyers in the room will be arguing and reminding the court that this first step, which is called the prima facie case, is designed to be easy. The Supreme Court terminology for characterizing this test is that it is not onerous. So, for example, when you look at what other evidence of discrimination is there to get over this hump, that's a pretty minimal requirement. So for example, let's say an employee was terminated and he had a colleague who was in the protected category who wasn't terminated. And there was even anything in the ballpark of sort of similar conduct by those two people. That would be enough. In fact, there's quite a bit of overlap between this fourth factor, other evidence of discrimination, and what I'm going to talk about in 2 steps later, which is called pretext. But I'll walk you through all the ways that you can establish other evidence of discrimination. But another way is just to say the employee was replaced by someone who was outside the protected category. Like automatically you get through on that. And there are, savvy employers who will deliberately replace somebody who's been terminated, and it may even be a discriminatory replacement, and hire somebody in the same protected category to try to eliminate the risk. But that doesn't eliminate the risk because there are lots of other ways that you can show other evidence of discrimination other than replacement. So this is, it's kind of a heavy test on the plaintiff. The employer literally doesn't have to do much. The next step is for the employer to come forward with A legitimate, non-discriminatory reason. So if we were to just boil that down, it just is a reason. They can pick whatever reason they want to, but for the management attorneys in the room and that are listening, you better pick your horse right, because what happens in the next step is that the plaintiff gets to shoot holes in your reason. And so you shouldn't take lightly the notion of, well, in a legitimate, non-discriminatory reason, I can say it was because he didn't look at me right. But really, if you don't pick your reason for termination wisely, you're going to have serious trouble at the next step, which is called pretext. So if I was explaining the pretext test to a juror, I would describe that as the BS test. Just establishing essentially that the employer's reason for the legitimate non-discriminatory reason is BS. In other words, it's not credible, or it's not true. It's not the real reason. And so that's where I go back to the notion of picking your reason for termination and picking a strong one, because at pretext, it will be under attack. So some of the examples of pretext evidence are, one is shifting reason. So you can understand a juror would look at an employer changing its story for a termination and say, that's fishy. And that happens all the time because, there'll be paperwork about why an employee is terminated, at contemporaneous to the termination itself. Then after the fact, a lawyer gets involved and is like, I don't really like that reason. I'm a little worried about it. So when he writes the position statement, he tweaks it. And now maybe it was one reason before, now it's two reasons. And then you get to the deposition, and the company decision maker isn't that well prepared, and now the plaintiff's lawyer got him to say, oh no, it was actually this third reason. So that is a changing story, and on that basis alone, a jury could find pretext, or a federal judge could find pretext, summary judgment. Another is a a positive employment record. So I love when we have an employee that's been working there for 20 years, never had a mark on his or her record, and then all of a sudden this young new manager comes in and he can't even chew gum and walk at the same time, and gets a bad evaluation. That sort of precipitous decline in performance is kind of textbook pretext evidence. Also skipping progressive discipline. So the management lawyers in the room are always telling their clients, don't rush to termination, because if you do that, and you didn't do that with people outside the protected class, now you've established a double standard between people. And also it just doesn't look bad, because just from a common sense, you expect a company to give, especially a long-term employee, an opportunity to improve. And a lot of times they don't. Now, in the rare case, every once in a while, you'll have something called direct evidence, which you could boil that down to saying it's an admission. So if somehow you end up with an email where the decision maker is talking about the termination at issue in the case and references something about how old the plaintiff was, and he was going to retire soon anyway. If the discriminatory comment or admission is tied to the discriminatory action, the adverse action, that can be direct evidence. And if you have that, you get through summary judgment automatically. You don't have to go through any of the other pretext steps. And then it's always a battle with company attorneys. Their job is to try to characterize this as a stray comment, not about, it's just not that important. It was just in passing. Remember locker room talk from the election? That's a similar sort of thing. It was just a stray comment, or it was about some other situation. So, and then I'll hand this off to Bill to talk about harassment.
All right. Josh did an excellent job giving you guys an overview of the McDonnell-Douglas test that applies when we're talking about discrimination claims. And that really is kind of a technical area, especially for summary judgment, as Josh covered. And it's an area that if you get into employment law, you're going to be very, very familiar with. One additional transition point I'll just mention in connection with that is, when looking at the prima facie case under McDonnell-Douglas, or then evidence of pretext as well, there's nuance that comes into play there in articulating, especially the prima facie case, quite frankly, on both the plaintiff and defendant side. There are slightly different articulations of the prima facie case depending on the context of the employment decision at issue, whether it's a termination case versus a failure to hire case. And it's really important to pay attention to that because quite frankly, it's an avenue to potentially win or lose the claim, plaintiff or defendant, really at that stage. So that's something to keep in mind as well. And again, the nuance there is a little beyond the scope of today, but certainly something to keep in mind. Another area that is really a subset of discrimination claims or disparate treatment claims, as Josh covered, are harassment claims. And a couple of key important things to keep in mind. Obviously, in today, in the media, we have this slew of sexual harassment claims and allegations and folks coming forward in all different walks of life. And so the hot button issue right now, of course, is sexual harassment. And obviously sexual harassment, as sex is a protected category under Title VII, that of course is prohibited. But it's important to keep in mind that harassment based on other protected traits is prohibited as well under the statutes. Again, it can be race, it could be religion, it even could be age or disability under the ADEA or ADA. So it's extremely important to keep in mind. The framework we're going to use, just for purposes of kind of keeping the discussion manageable, is really the sexual harassment framework. But for the large part, this sort of same framework applies, regardless of the trait we're talking about. And so we're going to dive into that next. Okay. So sexual harassment, from a legal standpoint, it's really been recognized in two different sorts of forms, quid pro quo and hostile work environment. Now, quid pro quo is the classic, if you do XYZ sexual favor for me, you'll get a promotion, okay? That is still out there, but pretty rare in the cases. The much more common one and much more commonly litigated one that you guys will face on the plaintiff and defendant side is the hostile work environment side. It's not a direct proposition necessarily tied to an employment action. Rather, it is what sort of work environment is going on, and does that work environment rise to the level of a legally actionable hostile work environment, okay? And again, the elements we're going through here, elements 1 through 4, pertain really to any sort of protected trait harassment you're trying to establish. But again, we're using sex here for purposes of the discussion. But in order to establish a hostile work environment, first of all, you have to establish that the conduct is because of sex. And we're going to get into a little nuance of what that means. You have to also show that the conduct is severe or pervasive, that the conduct's unwelcome, and finally, some basis for employer liability, okay? It's not necessarily automatic that you will have employer liability, even if you can establish the first 3 pieces to this, okay? So diving in, first of all, when we say the conduct is because of sex, it's much like all you guys would think, right? Obviously, sexual advances or touching, that's going to be because of sex. Hostility towards a particular gender can also be because of sex, even though it may not be sexual conduct per se, okay? You can also have sexually offensive language or visuals. There's a slew of cases regarding folks accessing pornography in the workplace, for example, or maybe posting things up in their cubicle. Those sorts of things could be because of sex as well, okay? An important note here is that when we say because of sex, there has been case law that has recognized same-sex harassment as well, as long as, again, that harassment is because of sex. So if you have a male harassing another male because of the second male sex, that's still actionable, okay? A key distinction, though, is this. Right now, there is a circuit split on whether or not Title VII covers discrimination based on sexual orientation, okay? And the cases do make a distinction between sex versus sexual orientation. The big issue with that right now is that the statute addresses sex. It doesn't explicitly state sexual orientation. Now, for several years, the EEOC has taken a position that sexual orientation essentially is subsumed within the notion and concept of sex, but not all courts right now agree with that. Okay, so there's currently a circuit split out there on that issue, and most recently, the Supreme Court denied cert to try to resolve it. As an aside, the case they denied cert on wasn't really a great case for them to decide the issue because there was numerous other ways in which the case could have been procedurally decided without them actually reaching that issue. So it wasn't a great opportunity, and right now we still have a little unclarity in that area. The other note we put up here is the issue of an equal opportunity harasser, okay? This comes up in cases from time to time, and for those of you guys that are going to practice on the management side in employment law, okay, this is a defense. It may not be the best defense you want to rely on, but if you have a jerk in the office who's just, nasty and to everybody, both sexes, right, you can bust out the equal opportunity jerk defense. And as Josh pointed out, when we're talking about disparate treatment, it means different treatment. And yes, if you actually have someone who is a jerk to everyone, that can be a defense. Obviously, you don't want to have to rely on that as your primary means of defending this sort of a case, and you probably have some personnel issues to address aside from the legal aspect of things. But that is a dynamic to consider here because, again, what we're really interested in and what the case law is interested in this area is, like Josh said, is different treatment, okay? And harassment is a type of that. All right, now, in showing that the conduct is severe or pervasive, as you might imagine, that's a very specific factual inquiry, and all of the cases are going to be slightly different depending on what facts exactly are involved. Okay, now, it is important to note that the standard is technically severe or pervasive. And, plaintiffs' attorneys love to point that out, and they say, well, it may not be severe, but it could be pervasive, and it's alternative. That's true, but the bottom line is, regardless, both sides have to consider the totality of what exact activity is going on in order to kind of establish or disprove this element. And obviously, courts are going to look at how frequent the conduct is, how severe the conduct is. If you have one really egregious incident, that could be enough to satisfy this. On the flip side, if you have a whole bunch of, relatively minor incidents where, one in and of themselves is not a big deal, but taken collectively it is, well, then that also could establish it, okay? And obviously, you're going to get into analysis of whether there's physical touching or not, whether it's merely an offensive statement, whether it unreasonably interferes with an employee's work performance, and a whole lot of other factors along those lines. One point from a defense standpoint, one point you might look at is to try to negate this. If the employee's work performance hasn't been affected and it's still good and they're still getting raises and everything along those lines, that is one factor you can point to say, well, wait a minute, this might have been going on, but is it really affecting your work environment in a negative way? That's something that comes up from time to time in these cases. Again, the standard is interesting in this area because it's an objective standard, but a subjective standard at the same time. So, the employee has to, perceive this to be an environment where they're being negatively impacted, again, because of sex. But at the same time, the courts have to say an objectively reasonable person in the employee's position would find it so as well. Okay. Conduct is unwelcome, okay? Again, this is a dynamic that definitely is in play in the sexual harassment cases. I will say in other types of harassment cases, needless to say, it's almost assumed that the conduct is unwelcome, right? If you're going to be talking about a race harassment case or something along those lines, it's going to be a pretty tough sell to say that that conduct is unwelcome. Maybe you could get into a situation where you have some sort of mutual joking going back and forth, but even then that's going to be very, very difficult in a litigation posture to show that. But in analyzing whether or not the conduct's unwelcome, courts look at a bunch of different factors. One is friendliness with the harasser. any sort of a delay in reporting the harassment or a failure to report the harassment. Obviously, if there's evidence of willing participation in sexual conduct, and for those of you guys on the defense side, social media is your best friend. If you're not conducting any social media searches on plaintiffs, again, legally, okay, you need to do so because there's often evidence of a consensual relationship that would obviously blow up any sort of an allegation that the conduct is unwelcome, okay? The employee's solicitation of the harasser's attention, such as things like provocative dress and things like that, and then prior consent as well. These cases, though, are never easy. You can have a situation where, as you might imagine, a relationship could be consensual for a period of time, and then all of a sudden it's not, right? And then you're left in this dynamic of the plaintiff, of course, will be focusing on the part that's not, or the time in which it changed, and of course, defense counsel would be pointing to the time of the relationship where everything was fine and dandy and everything was consensual, okay? All right, finally, we have bases for employer liability. And in order to kind of answer that, you have to step through a series of questions. And this is, I think, the easiest way of thinking about this. First, you have to ask who committed the harassment or alleged harassment. Did the harassment result in a tangible employment action, kind of like Josh was saying before about an adverse action, similar dynamic there? And what was the employer's response to the harassment? Okay. So first of all, when you're asking the question of who committed the harassment, if the harasser is a supervisor, this is kind of the framework that applies. If you have a supervisor harassment scenario and a tangible action resulted, from the employer's standpoint, you're pretty much done, okay? It's very difficult to defend that, at least from a liability standpoint. Yeah, you might be able to, make some arguments on damages, but from a liability standpoint, it's going to be, very difficult to mount a defense there. Now, if the harasser is the employee supervisor and a tangible action did not occur, well, then the employer can actually avoid liability if they can establish an affirmative defense through the framework established through 2 Supreme Court cases, which we refer to as the Ellerth and Faragher cases, okay? And that defense basically looks like this. There's 2 aspects to it. One is that the employer used reasonable care to prevent and promptly correct behavior that could be considered harassment, okay? Number of factors kind of go into that piece under number 1. Obviously, having a sexual harassment policy, either in your handbook or otherwise, that employees actually receive, not just one tucked away somewhere that collecting dust, but ones that the employees actually receive, that's going to go a long way towards addressing number 1. But also, harassment training that you might periodically conduct, that would be helpful as well. And finally, the dynamic of, all right, if the harassment is brought to your attention, what are you doing to investigate that and remedy the situation if there's a situation to be remedied at the time, okay? And 2, really kind of related to 1, and this is more so from the employee's perspective, did the employee unreasonably fail or refuse to use the employer's procedures for preventing, addressing, and correcting the harassment, okay? If you have an employee, for example, that is uncooperative in the harassment investigation, they've brought forth an initial allegation, and then you go to question them to get details, and he or she is reluctant to come forward with further details, or there was a delay on the employee's part in reporting, all of that could go to show kind of the second prong of this Ellerth-Faragher defense. Okay. If the harasser is a coworker, it's a little bit of a different structure and different dynamic from a proof standpoint. Really, it's more of a negligence standard at that point, okay? And the question is whether or not the employer knew or should have known of the coworker harassment, and again, what the employer did, once they did become aware to kind of address things after that. Am I still going? Yeah. Is that you? Okay.
Okay, so I'm obligated to talk about mixed motive, but for my plaintiff's attorney friends, I would rather you just put your fingers in your ears and not hear this, because this is sort of a trap if you were to proceed under this kind of construct. So I would refer to this as mixed damages instead of mixed motives, because if you go through this mixed motive method, you can only recover nominal damages in your attorney's fees. So how would you be helping your client if you were trying to prove there was a mixed motive at play, if you were severely restricting your client's damage recovery? And also in the jury box, they're already going to be trading and splitting babies. So you certainly don't want to give the jury an option of doing a horse trade that involves your client not getting any damages but still winning. So I'm going to speak very quickly about this. But the notion is the employer says, okay, you got me. Yeah, there was a discriminatory motive in play, but I would have terminated the employee anyway. And so, in other words, so it was such a big deal, so bad that the employer would have been terminated anyway. And that is essentially the employer's affirmative defense. We just, like Griff was talking about, we just had a trial. We didn't have a mixed motive instruction because, first of all, it's confusing and it's also bad on damages. But the flip side of that is that an employer would be smart probably to try to get a mixed motive jury instruction in there, because if the jury goes for it, the damages are limited. But the plaintiff's attorney would say, no, Judge, we don't even want that. We're not arguing under a mixed motive theory. But so let me move on because we don't have much time on that. All right, so the next method is called disparate impact, which, same thing, different impact. So what's nice about this is that you don't need to have a discriminatory intent if you can prove that the company had a policy or procedure that had a discriminatory effect on a protected class of people, even if there was no evidence that they were meaning to discriminate. So that's why they call it disparate impact. So this is a heavy lift for a plaintiff, because you have to essentially have a statistics expert to look at standard deviations and analyzing whether, if all things being equal, this negative impact on, say, African Americans could be rationally explained based on the statistics. So it's expensive to do. But also from a leverage standpoint, it is a very threatening claim to bring against a company, because like we did this before. We sued a large company for using a forced distribution instrument, an evaluation that you only can have 10%, or you have to rate 10% of the people an F. And then sometimes the company then had a policy of then managing out, 10 or 15% of people a year. And we challenged that, and we were only representing one employee, but because we challenged the forced distribution evaluation instrument itself, we ended up getting discovery on like entire divisions of people, got hundreds of personnel files and everything else. So you need, it's a heavy lift, but it can also open a gold mine of evidence. But in terms of how it works, if the employee has the burden to show that there was a facially neutral employment practice that had a disparate impact, and then that then the burden shifts to the employer to show that the challenged practices are job related. So in other words, it wasn't just random; they were job related and relevant to the job. And then the burden then shifts back to the employee to prove that there were less discriminatory ways of doing it. So, I've only ever filed one disparate impact claim, in my time as a plaintiff's attorney, but when you have the evidence, it's worth a go. All right, the claims that we like the most as plaintiffs' lawyers, I think we'll readily admit, are retaliation claims. I think jurors inherently and judges inherently understand that when you rock the boat, there are consequences a lot of the time, and they just know that from their everyday life. And so, there are academics that have looked at success rates for discrimination claims versus retaliation claims, and the retaliation claims do better, especially on summary judgment. So, when we're vetting cases, if we see a retaliation component, it's more likely that we're going to take a case. All right, so what is retaliation? So first of all, your client going to a supervisor and saying, so-and-so was mean to me, or so-and-so was unfair, the evaluation had wrong information in it, that is not what's called protected activity, because in order for your conduct to be protected from retaliation, you have to have been opposing a discriminatory action at work. So if we change the verbiage, and the employee was saying, my manager is treating me differently because I'm a woman, and this male colleague did way worse than I did, and he got a better evaluation or a better raise, you've now opposed a discriminatory action, and the law protects you. So when you're consulting with a potential client about, do you have a retaliation claim, you literally need to get the quotes that they used verbally or in emails to be able to assess whether or not it's protected. You're also protected from making an internal complaint of discrimination, even if it's to HR, even if it's to your immediate supervisor. You're obviously covered as well from retaliation if you make a complaint with the EEOC, and Bill will be talking with you about that EEOC process. All right, so another category of protection is pregnancy discrimination. That is covered under the rubric of sex discrimination. So, stated pretty plainly, you have to treat a pregnant employee the same way that you would be treating a non-pregnant employee. And it amazes me, like just in the last week, we got 3 pregnancy discrimination claims, calls. And it always has to do with a woman gets pregnant. It's in a work setting where there might be a little bit of lifting or manual labor, and not based on a doctor's restriction, but based on a manager's own perception of this pregnant worker as saying, oh, no, we can't have you doing that work anymore. We're going to give you a light duty work, or we're going to cut your hours, or let me do you a favor. Just go out now, you're pregnant, I'll hire you when after you have your baby. And the employer thinks he's helping the pregnant woman out, but that is actionable discrimination, and it happens all the time. One nuance about pregnancy discrimination is a reasonable accommodation. So if you were asking me how I would write the law, I would say a pregnant woman should have the right to be reasonably accommodated, just like a disabled person is when you learn about, when you're familiar with the Americans with Disabilities Act. But there isn't an actual reasonable accommodation provision in the Pregnancy Discrimination Act. But the way we get around that is, an employer needs to give reasonable accommodations to the guy who hurt his back and is on light duty. If they're accommodating a man who had a light duty restriction, you have to accommodate the pregnant woman in the same way, because it's discrimination, regardless of whether there was a duty to accommodate or not. But there needs to be an equal playing field. All right, so pay discrimination. Obviously, discriminating against somebody, a woman or an African American, it doesn't matter based on pay. That certainly rises to the level of an adverse action. And so if you're a plaintiff's lawyer, every time that you're having a consult with a client, a lot of times the client is not focused on identifying a pay discrimination issue, but you should be probing for one, because these are nice companion claims to bring with a discrimination claim. And it also opens up a whole can of worms in discovery, because now normally, Bill would be zealously representing his client and saying, heck no, I'm not giving you compensation data on the comparators. Why do you need that? But if we've made an allegation that there was disparate treatment as to pay, we might open up a gold mine and be like, wow, this is actually a broader problem at the company. So these are good claims to bring, but I don't think I brought a freestanding Fair Pay Act claim by itself. They're not. It happens all the time, but there isn't a lot of litigation in those sorts of cases. All right, and then finally, before I turn it over, failure to accommodate claims. So the Americans with Disabilities Act, I'm not sure if we have a presentation on that act, but there's a whole body of law about how an employer needs to reasonably accommodate an employee with a disability. But there's also a duty to reasonably accommodate somebody who is based on religious grounds. So, for example, a Seventh-day Adventist, I think they don't work on Saturdays or Sundays. I forget, but if you have a Seventh-day Adventist that works for the company, he or she can say, look, this is my religion, and I can't work on this day, or for Jewish folks, it's the Sabbath, say. There's a duty to reasonably accommodate that, that religious requirement. All right, thanks. Oh, sorry, Molly. I false started. And then the Equal Pay Act, the standard is very similar to the pay discrimination provisions in Title VII, but you would bring an Equal Pay Act claim as a plaintiff because you can get double damages on the pay disparity, which you don't get under Title VII.
All right. I'm going to give a brief overview of kind of the, procedure, if you will, when one of these types of claims is brought before the EEOC. One point I wanted to mention before I dive into that, though, and I just simply couldn't resist because it's a really interesting kind of nuance to consider. Josh talked a little bit about mixed motive in this last session where he just presented. The mixed motive framework, and I actually just go back a couple slides so you guys can see what I'm talking about here. This is the statutory language from it. What's a very interesting question, and it's kind of incredible that this question is still open, considering this was an amendment made to Title VII back in 1991, is whether or not now the framework for Title VII claims generally is a mixed motive framework across the board. In other words, does mixed motive operate within this McDonnell-Douglas pretext framework that we talked about this morning, or rather, is it kind of an alternative? And I think most practitioners, kind of like how Josh presented, assume that it's an alternative, that a plaintiff doesn't necessarily have to proceed that way, and accordingly, perhaps maybe an employer doesn't have to defend that way. But I will tell you this, there are some judges who believe that this applies across the board, especially when it gets to a jury trial phase of the case. And so accordingly, you need to be familiar with this framework. What is interesting, and I think kind of an unintended consequence of this, the design behind this amendment was to try to make proving Title VII claims easier, because it interjected this whole motivating factor language. But as Josh presented, what's actually happened as a result of it is almost the complete opposite. Because of the limitations on damages, if the employer can show that they would have made the same decision, the plaintiffs then become steering away from wanting to have a mixed motive framework to the case, whereas the defendants in these sorts of cases would like to have that, in certain circumstances at least. So it's very interesting. We do not have a definitive answer in the Fourth Circuit or by the Supreme Court as to whether or not all Title VII claims are actually subject to this framework. I would argue statutorily that they are not, mainly because of this first phrase here where it says, except as otherwise provided in this subchapter. So even the statutory text is trying to create a carve-out of sorts before it goes on to articulate the motivating factor or mixed motive rule. There's not a lot of well-developed case law on this point in the Fourth Circuit. As an aside, my research has shown the Third Circuit to be the best circuit where they've actually kind of addressed this issue and tried to wrestle with this dynamic. And they've concluded that not every case is a mixed motive case. A large part of that is going to depend on the theory advanced by the plaintiff in the case. So just wanted to add that piece to kind of the discussion for something for everyone to keep in mind. Okay, so going to the EEOC and kind of what to expect, it's important to understand this with this area of law. If you're talking about a Title VII claim, for example, before you can file a lawsuit, you have to bring an administrative charge of discrimination with the EEOC. The EEOC's job is to investigate these charges and get down to the bottom line question of whether or not discrimination actually happened. Okay. In terms of who can file a charge with the EEOC, again, kind of like Josh said, there's a prerequisite there, of course, of having an adverse action, and employees can file discrimination charges, retaliation charges, harassment charges, and everything along those lines. But it is important to understand that what you put in the charge is going to constrain you for purposes of litigation down the road. And one of the first things, if you're defending these sorts of cases, that you want to look at from an employer perspective is, what is the scope of the charge? Because the scope of the charge is largely going to determine the scope of the lawsuit. And if all of a sudden in the lawsuit phase, there's all these brand new theories and new events being alleged that weren't contained in the charge, well, then you have an argument that the plaintiff has failed to exhaust his or her administrative remedies. Because really, if you think about it, the whole point here is to give the EEOC the upfront opportunity to investigate that. And if the employee's not doing that, then that kind of, negates the whole purpose of why the EEOC is there in the first place. Okay. A couple points on this is, in North Carolina, we're a non-deferral state, meaning that we don't have kind of an associated state agency that takes these sorts of claims in. So there's a 180-day time limit for an employee to file a charge with the EEOC from when the adverse action happened. Okay. There's a little nuance to that, and it's discussed a little bit more in the manuscript that Josh, and I guess also Griff, put together, which you guys have in your materials. But it's important to understand that the 180 days runs from the adverse action, not necessarily the impact from the adverse action. So if there is a delay between when the person really feels the harm of the decision they're challenging versus when the decision happened, you've got to keep in mind that 180 days runs from the earlier event. Okay. In terms of practice before the EEOC, just generally what to expect as an employer, when you receive a charge of discrimination, you're going to be preparing a position statement in response to that. Josh mentioned the position statement dynamic a little while ago when he was discussing disparate treatment, and it's extremely important to take that step carefully. Josh illustrated the point of, your reasons for termination that are articulated in the position statement better be accurate, or plaintiff's attorneys are going to jump all over that later on down the case. And so it is a part to take extremely carefully and methodically. With that, once you submit a position statement, the EEOC will then have, of course, the employee's perspective and the employer's initial perspective. After that point, the EEOC will often then follow up with the employee to get their take on the employer's position statement, as you might imagine. And from there, any number of different things can happen. The EEOC might send a follow-up request for information, asking for more information from the employer. The EEOC does have the ability to come out and do an on-site investigation and interview folks with the company, or anything else along those lines. And the EEOC will ultimately conclude whether or not discrimination actually exists. And if it does, and they find cause, there'll be a conciliation process where the employee and employer try to work out the dispute. If there's not, the employee will get a dismissal letter, and the employee still, even if the EEOC does not find cause, they still have 90 days to file a federal lawsuit from their receipt of that letter based on the allegations. So for those of you guys going into management work, you will have the wonderful luxury of announcing a victory to your client, only to find out 90 days later that now they're being sued, okay? That happens from time to time, unfortunately. So I always tell people not to get too excited when they get a dismissal. It's really the dismissal and then the 90 days afterwards that matters, okay? So that's important to keep in mind in terms of kind of the time frame there. Looks like we actually have let's see here. We actually have one question, and so I'm gonna try to address this question. Here's the question that we received in here. What if the employer employs employees on a client's site and one of the client's employees sexually harasses the employer's employee? Can the employer be held liable? Would the negligence standard apply? Great question. Okay, so this is the dynamic of where you have, going back to the harassment piece for just a second, this is a situation where you have the harasser as essentially a third party. It's not an employee of the employer, but someone on site with that person in some way. And can the employer be held liable for this third party's actions? The answer to that is yes. And a similar framework to the coworker harassment framework would apply. The reason for that is this. The harassment cases are addressing the workplace environment. That workplace environment could be affected by employees. It could be affected by third parties coming on that might have some sort of a business relationship with the individual. There's even cases actually where harassment allegations are being generated based off of customer interaction with the employer. So yes, as an employer, accordingly, you need to take extremely seriously any complaints about harassment, regardless of the origin of where they're coming from. So that's a great question. All right. Again, I kind of skipped ahead on some of these charges, or some of these slides on the charges here, and want to just briefly cover some of the remedies available under the statutes as well. Obviously, one of the big remedies, of course, is back pay. Back pay being, the time in which the employee, from the adverse action up into the time of judgment would be a back pay period. Okay, that is available under Title VII and the related federal statutes. Reinstatement is a possibility, although more frequently awarded is some, amount of front pay in lieu of reinstatement. Compensatory and punitive damages are also big ones. Okay, so you can receive damages for emotional distress, everything along those lines, and related damages, and also punitives as well. And there are statutory caps that apply on those, but those are available damage components. And then, of course, the big driver for this type of litigation, really on both sides of this, that the parties need to be concerned about are, a successful plaintiff can recover his or her attorney's fees. Okay, and so that is an economic component that, again, might drive a plaintiff to take a particular case, and also as a settlement component that has to be considered, from a defense side as well. Okay, and the caps that I mentioned on compensatory and punitive damages, statutorily, they're actually dictated by the size of the employer, and they deal with the number of employees, that the employer has. So if you have 15 to 100, the cap on compensatory and punitives combined, it's actually a combined cap, is $50,000. If you have 101 to 200, it's $100,000. 201 to 500 is $200,000, and if you have over 500,000 employees, there's a $300,000 cap. Okay. The next presentation is going to be addressing types of claims where there are not caps. Okay. So it's important to keep in mind, plaintiffs' attorneys love the no caps. I love these caps, okay? These caps are great from a defense standpoint. But, certain claims have these, under the federal law. State law-wise, you're not going to be operating under this construct. Okay. And finally, similar remedies apply with respect to an ADEA claim, although with respect to an ADEA claim, you're not having compensatory or punitive damages. And accordingly, there's no cap on those because the damages aren't available in the first place. And that is the end of our presentation. We really appreciate your guys' time and attention.
Actually, I just wanted to add.
Add one more.
Actually,
Perfect.
Griff wrote the manuscript. You wouldn't want to read it if I wrote it. I just updated it. Or was it Hoppy?
I have no idea.
No, you did. I just wanted to make sure you had the proper attribution. But okay, thank you.
Thank you, guys. Thank you.